Thank you. Good morning, everybody. Well, as Mr. Dini put it, there are several traps when you practice before the EPO, and it's my turn to tell you a little bit about the traps before the EPO. So I want to put it a little bit broader than it's said here on the slide. There's just one inescapable trap, but there are several points to note how to avoid problems under Article 123 EPC. The Article 123 EPC is basically an article saying you should not use added subject matter in the claims. That's not supported by the original disclosure. So let's get into it. Well, we have Article 123(2) EPC saying the European patent application or European patent may not be amended in such a way that it contains subject matter which extends beyond the content of the application as filed. Well, I think that's nothing new. That's also similar in other jurisdictions, in other patent systems. But now comes the additional Article 123(3), meaning the European patent may not be amended in such a way as to extend the protection it confers. So, you start with a patent application, you amend the patent application in a certain way. During amendment, you may enter certain features into the claims, and maybe these certain features may not be supported. They may not be found in the original disclosure. So you may contravene Article 123(2). But the patent is granted. Now you have the situation that the patent is granted, and now you are confronted with Article 123(3) saying that the patent may not be amended in such a way that the protection is broadened or altered or anything else. So that brings us to the decision of the Enlarged Board of Appeal, G1 out of 93, basically, which is the problem with respect to the inescapable trap. Well, if a European patent as granted contains subject matter extending beyond the application as filed, which also limits the scope of protection, such patent cannot be maintained in the opposition unamended, since it would violate the under Article 123(2). Nor can it be amended by deleting the subject matter from the claims, because if you would take out this subject matter, the one feature, for example, that is not supported, then the amendment would extend the protection conferred, which is prohibited by Article 123(3) EPC. So this is basically the situation you may run into if you, during your application proceedings, amend the claims in such a way that it's not supported. And the European Patent Office is very strict with what is being supported and what not. So usually you would have to found the features that you use, that you enter into a claim literally in the other claims. If you add anything from the specification, also there it should be found literally in the specification. So this is a real problem. So now I may give you an example. Well, first of all, the rest of the decision, Well, such a patent can only be maintained if there is a basis in the application as filed for replacing the added subject matter without violating Article 123, so without broadening or changing the scope of the patent. Well, if such a basis for an amendment cannot be found, then the patent must be revoked. Well, if a feature that is not originally disclosed, which has been added to the application during examination, and merely limits the scope of protection without a technical contribution to the subject matter of the claimed invention, is not considered as subject matter extending beyond the content of the application as filed. In this case, the patent may be maintained as granted in view of the ground for opposition. Well, however, talking about features that are important to the invention that are not found in the original disclosure, and then talking about features that are not important, they do not have any technical contribution, anybody can understand we will have very, very rare cases where we would have such possibility, because usually the EPO will say everything is important. So everything will have some kind of technical contribution. So this escape route would be not really, it's just very, very, very few cases that would offer this escape. So now let's come to an example. Well, Claim 1 of the application as filed protects a device just comprising features ABC. Claim 1 as granted protects a device comprising features ABC and feature A1. Feature A1 may be a feature very similar to feature A, but it's a different feature. So support cannot be found for feature A1 in the specification. It cannot be found in the other dependent claims. It cannot be found in the drawings. Anyway, for support for new features simply from the drawings would not be sufficient anyway. So if feature A1 further limits feature A or further limits any other, it must not limit further feature A, it's just a further limitation. Then it cannot be unambiguously derived from the application as filed, from the claims, specification, drawings. The patent must simply be revoked, because the Article 123.2 cannot be remedied without violating Article 123.3. So there's another example. We have in the claim, we have a range of a parameter, such as an annealing temperature for crystallizing a glass ceramic, which was given in the original application as 1000 centigrade to 1300 centigrade. But to some reason during the application proceedings in the patent, in the granted patent, it's now claimed that the range is 1200 centigrade to 1250 centigrade, resulting in a special effect. In addition, there's no claim in the application as filed directed to the annealing temperature of 1200 to 1250 centigrade. Well, in this case, it's just looked whether the 1200 to 1200 centigrade range is somewhere found in the other dependent claims or is somewhere found in the specification. So it must be literally found. So if it cannot be found, then we have a problem. Well, the specification may talk about the importance of the annealing temperature without discussing the range of 1200 to 1250 centigrade. So it cannot be literally found in the specification. However, there's one example in the range of 1180 to 1230 centigrade. Well, in the claim, it said 1200 centigrade to 1250 centigrade. Support can... Well, if the example would disclose an annealing temperature range of 1210 centigrade to 1230 centigrade, then it could be used as a basis for amending the claim. However, as a previous speaker already told us, in this case, we would have to deal with the specifics of the example. So the EPO would require us to include all the specifics of the example, of the particular example, into the claim. So that would, in some cases, it would lead to a very narrow claim. However, it would just give us a rescue from revoking of the patent in total. There's another example. Claim 1 of the patent as granted protects a drilling machine having a specific chuck for clamping drills. The construction of the chuck may improve a fast changing of the tool. However, Claim 1 contained a further feature indicating that the housing of the machine is made of a particular plastic, namely ABS. But this additional feature that the housing is made of ABS, is that for this feature cannot be found any support. The application as filed, it's only disclosed that the housing was made of PVC without giving any information with respect to the reason therefore. So it's not discussed why the housing should be made of any particular plastic. So this may be an example for a case where it can be said that the additional feature that is not originally supported, that's not disclosed, is not does not give any technical contribution to the invention. In this case, that might be a possibility where an amendment would be allowed and where it could be an escape from the trap. However, I mean, that's already a pretty theoretical example, and as I told you before, it's very, very difficult to find a case at all where you really would be allowed to make such an amendment, since usually if it's entered into the claim, usually it has some importance and it has some technical contribution. Always the opponent and the EPO itself will usually claim it's important, maybe a little important, just a little technical contribution, so it will be very difficult to find an escape. So if the additional feature that the housing is not made of ABS, in this case does not contribute in any way, then it may be allowed to make this amendment without violating Article 123 2, and 3 EPC should be correct. So now I want to talk a little bit about amendments that are allowed before the EPO without violating Article 123 EPC. So this is a change of category. So this refers to application proceedings as well as in some cases also to opposition proceedings once a patent is granted already. So usually it's possible to amend a product claim of a granted patent to a use claim, use of a product for a particular purpose. So why should that be allowed? I mean, a product claim protects everything. It also protects every use. So an amendment to use of a product for a particular purpose would be a narrowing of the claim. However, usually that's only possible if, of course, the particular purpose and the particular use is disclosed already in the specification. Otherwise, that's not possible. But in general, if there is sufficient support, then you would be allowed to make this change of category. Also, it would be possible to amend a product claim to a process for making such a product if the process itself is disclosed, of course. In this case, also it would be considered a narrowing of the claim, since a process for making a product would be considered narrower than the product itself, which is the broadest protection. It would not be possible to amend a process claim for making a product to a claim directed to the product itself, because the product claim, as I said before, is the broadest category, and that would be usually not allowed. Well, basis for amendments after grant of the patent is usually the application as originally filed. So you may not be, it may not be necessary to just compare the patent as granted with the particular amendment. So you can really look into the original application as filed. If the original application as filed was a PCT application, then the PCT application would be the basis for the amendment. However, if it is made clear in the patent specification that particular features that were originally claimed are not protected anymore, such as indicating with respect to a particular example that it's not covered anymore by the patent, such features may not be reintroduced into the claim. So during application proceedings, it might turn out that particular features are already known in the art. So to get the patent granted, you may have to include into the specification some description that these features are not covered anymore. When the patent is granted and there is an opposition, then in this case you would not be allowed to reintroduce these features into the claims. Now some strategies what you should take into account before filing a European application, just to avoid these problems under Article 123. Hopefully, I'm not taking too much from your space. So before filing a European patent or even a PCT application, You should review the claims for unnecessary restrictions. Note that the PCT application forms the basis for the original disclosure. So this is an important point for all the foreign clients that file PCTs that later go to Europe and will enter the European regional stage. Because the PCT sets the scope for the original disclosure, this is it. So you have to take into account what you draft in your PCT application. So you should include as many optional and preferred features. So you may use in particular, preferably, etc., as necessary in the claims to provide a sound basis for later amendments. For ranges, you may use nested ranges, such as 10 to 100, then next 20 to 50, 35 to 40, and so on. Because in this case, you will not run into the problem that explained before in the example. Or even better, you may use subsequent upper and lower limits, maximum 150, 40, etc., and minimum 10, 20, 35, etc., preferably in different claims. So you should avoid to rely only on the specification to provide a later basis for amendments. Because, as the previous speaker already told you, it's very difficult to enter amendments from the specification. First problem would be usually they are not searched. Second problem would be that you may be limited to the just particular example, and that would be maybe very narrow. So you should keep in mind that the specification and drawings usually cannot be used as a basis for amendments providing a broad scope. The examples given in the description of particular embodiments only relate to the particular example and cannot be generalized. So a basis for further amendments should usually be included in the introductory part of the description in broad general terms. I mean, that would be a possibility in addition to the dependent claims to include these descriptions of further, just to provide a basis for further amendments. However, usually if you try to use a feature that it's only in the introductory part of the description, even in general terms, you may be allowed to do that. However, the problem will be it's not searched. So in this case, you may be forced to file a divisional. But at least it's better you have the basis for further amendments if you just don't have any basis. Apart from that, only the claims should be used as a basis for later amendments. So the best strategy is to put everything into the claims. However, the problem before the EPO, usually if you don't want to pay a lot of money, you are limited to 15 claims. So this is really a problem to put every important feature into 15 claims. So if that's not sufficient and you want to save money, well, you could use the strategy to put some additional features and explanations of their importance and so on into the introductory part of the description. In particular, not into the part of the description which refers to the preferred embodiments, because that would be only very limited examples. Well, when you make any amendment, you should check each amendment for support by the original disclosure, and you should look whether it's found literally in the original disclosure. In some cases, it may be even proposed by the examiner, and the examiner may be wrong. So a patent may be granted just because the examiner just suggests, why do you not enter this feature into the claim? And the patent will be granted, and later on you may find out there's no support, and then you run into trouble. So if there remains some doubt, you should further check whether the amendment, if maybe not supported, could later be remedied by providing more specific information in the claim that is clearly supported, so which would lead only to a smaller scope of protection. So if there may remain some doubt, you may go with the examiner and you may get the patent granted just to avoid this inescapable trap. It should be clear from the very beginning that in this case there's sufficient support so that you can amend the claim so that it leads only to a narrowing of the claim, so a narrowing of the scope of the claim. In this case, there wouldn't be any problem. It would be only limiting the scope of the claim. Well, a generalization can later be remedied by the specific amendment that is supported if the scope of protection is only narrowed. However, a particular feature that is not clearly supported by the original disclosure cannot be replaced by a broader or different feature, even if supported, because it will broaden or shift the scope of protection. So, avoiding problems before filing an EP application, the EP application should be reviewed at least with respect to the claims for, well, broad claims, just avoiding, of course, the problems that the previous speaker pointed out. Then not more than one claim in each category, because otherwise you would run into the problem of unity of invention, as also pointed out before. Dependencies should be as broad as possible, so you should use multiple dependencies. And fallback positions should be in the dependent claims, not in the specification. If necessary, fallback positions should be added to the introductory part of the specification, just for possibly reducing the number of claims to the maximum of 15, but only for this case, because you may run into the problem of filing a divisional. And note that the PCT applications should be drafted in the same way. Thank you.